Welcome to the Deep Dive. It is August 18th, 2025. And, well, there's some big news today. President Donald J. Trump has just announced a pretty significant move, a new executive order aiming to ban mail-in ballots and voting machines nationwide. This is before the 2026 midterms.
Wow. Okay. That's major news.
Yeah, he's claiming mail-in ballots are, quote, corrupt. And he's arguing that states are basically just agents for the federal government when it comes to counting votes.
Asserting federal authority over state processes, then.
Exactly. He says this gives him the power to set rules for everyone. He even mentioned Putin supposedly supporting the idea.
Okay.
And, this isn't the first time we've seen something like this from him. Remember back in March?
Right. Executive Order 14148.
Yeah.
The one about proof of citizenship and decertifying machines.
That's the one. And it got blocked pretty quickly by a federal court, at least parts of it. The president keeps arguing the U.S. is behind other countries on election security. He points to, like, India and Brazil using biometrics.
Instead of self-attestation for citizenship.
Right. And he's also claimed, incorrectly it seems, that the U.S. is the only country using mail-in voting.
Which we know isn't true.
Definitely not. So today, we're really diving into this central question. It kind of strikes right at the heart of our democracy. Who actually controls our elections? And what does the data, the real evidence tell us about election integrity?
That's the key question, isn't it?
Yeah. So we're going to put on our detective hats, unpack the sources you've shared, everything from legal history to these latest executive actions. Our mission really is to arm you, the listener, with the important nuggets, the key facts to understand these pretty complex issues, cut through the noise.
Sounds good. Let's get into it.
Okay, so let's start with that term, election integrity. We hear it all the time. But it seems like people start from very different places when they use it. What are these main sort of competing views? How do they frame things?
Well, it's fascinating, actually, how these core beliefs really act like different lenses. They shape policy, they shape the whole debate. So on one side, you have a perspective articulated by Nicholas J. Stark from Liberty University, which really prioritizes fighting voter fraud.
Okay, fraud first.
Right. This view argues fraud is, quote, rampant, and that it meaningfully impacts election outcomes. The idea here is that if you relax voting laws, well, you're just inviting fraud. So the solution, from this viewpoint, is stricter laws, things like tough voter ID, limits on mail-in voting, to secure the process.
Got it. Security through stricter rules. What's the other side then?
Well, Stark also identifies the other main view, which sees the biggest threat not really as fraud, but as voter suppression.
Ah, okay. So access is the key concern there.
Exactly. This perspective argues that those very strict laws, even if they're intended for security, end up creating barriers. Barriers that stop legitimate voters, especially, they argue, minority groups, from casting their ballots.
So they'd say relaxing laws is better for integrity.
Yeah, essentially. They contend that relaxing laws, expanding access, things like mail-in voting, automatic registration, that's what boosts turnout. And for them, high turnout, broad participation, that's the real measure of election integrity. They see strict laws as leading to lower participation.
So it really just boils down to two different fears, doesn't it? Fear of illegitimate votes versus fear of excluding legitimate ones.
That's a great way to put it. And it sets the stage for conflict on almost every specific voting method.
Right. So where do we see these clashes playing out most obviously in, like, policy debates right now?
Oh, absolutely. The biggest battleground, especially lately, has got to be mail-in voting.
Makes sense, given the news today.
Totally. So those worried about fraud, they tend to push for in-person voting, often with that strict ID requirement. They see mail-in as just inherently less secure, maybe open to coercion or manipulation.
Okay.
But then those prioritizing access, they champion mail-in voting. They see it as, super convenient, essential for people who can't easily get to the polls, maybe because of work or disability or childcare.
So it's a perfect example of those two philosophies just clashing head on.
Exactly.
Okay, that leads us right into it then. Mail-in voting. The president just called it corrupt, prone to fraud. But what does the actual evidence, the research you've looked at, tell us? Is there data to back up these widespread fraud claims linked to mail-in ballots?
Yeah, this is where looking at the data is so crucial, and it paints a surprisingly clear picture, actually. There's a technical report by Jonathan Auerbach and Steve Pearson. These are folks from the American Statistical Association. They did a really deep dive, analyzed over 2,200 documented voter fraud cases. This is between 2000 and 2020.
A big data set.
Huge. And their conclusion, they found, quote, No evidence that voting by mail increases the risk of voter fraud overall.
No evidence of increased risk. That's pretty definitive.
It is, and what's maybe even more striking isn't just that it doesn't increase fraud. Their findings suggest that in states that have really embraced mail-in voting, fraud rates seem to have actually declined, sometimes significantly.
Declined,
Yeah.
really?
Yeah. So since 2016, they looked at states that automatically mail ballots to all registered voters, they call those VBM, vote by mail states, and they compared them to states where lots of people choose mail ballots, RBM states, and states that mostly use in-person voting. And the VBM and RBM states, they reported fraud rates that were similar to or even lower than the other states.
Wow. So the states using mail-in the most have the same or less fraud.
That's what the data indicates. To give you some numbers, RBM states where people request mail ballots saw their average fraud rate drop from about half a case per million voters down to less than a third of a case per million.
Tiny numbers already, getting smaller.
Exactly. And for VBM states, the ones mailing ballots automatically, the decline was even sharper, from about 1 case per million down to just a quarter of a case per million voters.
So basically statistically zero.
Pretty much. It makes these claims of, massive widespread fraud very hard to square with the actual recorded instances. They even estimated that Washington state, after it brought in its VBM law in 2011, probably had about 80 fewer fraud cases than it would have otherwise.
80 fewer, okay.
And Utah and Washington. According to the Heritage Foundation's own data set, they reported 0 fraud cases after 2012. 0.
That's really counterintuitive given how much we hear the opposite.
Right.
So if the data doesn't show this surge in fraud, why there really strong, persistent claims against mail-in voting?
Well, that's the million-dollar question, isn't it?
And what about that claim the president made, that the U.S. is the only country using it?
Right. Well, stepping back, experts like Debra Cleaver from Vote America often call these widespread fraud claims a myth, precisely because the data just doesn't support them on that scale. And it's important to remember, mail-in ballots aren't just loose pieces of paper. They have security features.
Like barcodes, signatures?
Exactly. Barcodes for tracking, signature verification processes, often bipartisan teams reviewing them. Remember Christopher Krebs?
Yeah, former cybersecurity chief.
Right. He called the 2020 election the most secure in American history, and that included a massive amount of mail-in voting.
Okay, so security measures exist. What about the international comparison? Are we alone in using mail ballots?
Not even close. That claim is just factually incorrect. More than 30 other countries allow voting by mail for at least some, if not all, of their voters.
30. Like who?
Oh, established democracies, Canada, the UK, Switzerland, Germany, Denmark. Lots of places have used it successfully for years.
So the U.S. is definitely not some kind of outlier there.
Not at all.
Okay, so if the numbers don't really support the big fraud concerns with mail-in voting and other democracies use it fine, this brings us back to that core legal question. Who actually has the power to make these kinds of sweeping changes, like banning mail-in voting or machines nationwide the way the president is trying to?
Right. And this is where the U.S. Constitution lays out the framework. And it's actually pretty clear on this point. The authority over running elections, the administration part, is primarily divided between the states and Congress.
Not the president.
The executive branch has a much more limited role, constitutionally speaking. This is laid out really well in sources like that CRS report by Kenneth Thomas, that's the Congressional Research Service, Nonpartisan Analysis for Congress.
Okay, so states and Congress, how does that division work?
Well, the Constitution basically gives the first crack at it to the states. Article 1, Section 4, Clause 1, it's called the Elections Clause. It explicitly says state legislatures get to set the times, places, and manner of holding elections for senators and representatives.
Times, places, and manner. Okay, that sounds pretty broad for the states initially.
It is. And that's why historically states have handled most election mechanics, voter registration, polling places, ballot design, all that.
But you said Congress is involved too.
Yes. The same Elections Clause gives Congress the power to, quote, at any time by law make or alter such regulations.
Ah, so Congress can override or supplement state rules.
Exactly. And they have. Setting a uniform federal election day, that was Congress using this power. Congress also has broad authority to protect election integrity, generally speaking. They could even, in theory, postpone a federal election, though not forever because terms of office are fixed.
So where does the president fit into this state-Congress dynamic?
That's the crucial part. The Constitution's text simply does not grant the president inherent power to set these rules. There's no clause saying the president can establish election dates or postpone them unilaterally or dictate how people vote nationwide, like banning mail-in ballots. That power isn't textually given to the executive.
Okay, so if the president doesn't have that inherent constitutional power,
Yeah.
how can he even issue executive orders trying to do these things? Like the one today, or the March one on citizenship proof. What's the legal basis or attempted basis?
That's an excellent question. It gets right to the limits of presidential power. A president can issue executive orders, yes. But that authority usually has to be tied to power granted by Congress in a specific law, either explicitly or implicitly. It's not usually a blank check rooted only in the presidency itself for domestic affairs like this.
So he needs Congress to have given him the authority somehow.
Generally, yes, or be acting based on a specific constitutional power he does have, which doesn't seem to apply directly to setting the manner of state-run elections. The Supreme Court has weighed in on this a lot. The famous case is Youngstown Sheet and Tube Can Sawyer back in 1952.
The steel seizure case.
That's the one. President Truman tried to seize steel mills during the Korean War, claiming national security. The court said no, and Justice Robert Jackson wrote a really important concurring opinion. He basically said presidential power is strongest when acting with Congress's support,
Okay.
and at its lowest ebb when acting against what Congress wants, or in an area where Congress has deliberately not acted.
Lowest ebb. So acting against Congress is the weakest position.
Right. So could Congress delegate power to the president, maybe to postpone an election in a true catastrophe? Perhaps. But they'd have to be really clear about it, set specific standards to avoid violating that separation of powers principle.
And what about the courts? Can they just overturn these orders?
Absolutely. That's judicial review. Federal courts, all the way up to the Supreme Court, can examine executive orders. They can strike them down if they find the president didn't actually have the authority to issue it in the first place, or if the order itself is unconstitutional.
Which is what happened with parts of that March order, right? The court blocked the citizenship proof part.
Precisely. The court stepped in and said, hold on. Does the president have the authority to impose this specific requirement on mail voter registration? And at least initially, they put a pause on it. It's the judicial check in action.
So it really sounds like the president's argument that states are just agents of the federal government. That really clashes with this long-standing constitutional setup of shared state and congressional power over elections.
It certainly appears to run counter to the traditional understanding, yes.
Now, besides these executive actions, state legislatures themselves have been really active changing election laws. And one moment that seems to have opened the door for a lot of changes was that 2013 Supreme Court decision, Shelby County v. Holder. What exactly did that do? And what was the impact?
Yeah, Shelby County was, well, it was a landmark decision, a real game changer for voting rights law. It effectively gutted a key part of the Voting Rights Act of 1965. Specifically, it struck down the formula used to determine which states and counties needed pre-clearance.
Pre-clearance. Remind us what that was.
Sure. So under the original Voting Rights Act, jurisdictions with a history of racial discrimination in voting, mostly, though not exclusively, in the South, had to get approval from the federal government before they could implement any new voting laws or procedures.
Okay, so a federal check on changes in those specific places.
Exactly. It was a powerful tool to prevent discriminatory laws from taking effect. Shelby County didn't strike down preclearance itself, but it invalidated the formula for deciding who was covered. Congress could have created a new formula, but it hasn't. So, effectively, preclearance is dormant.
And the impact of removing that.
Well, stepping back, it essentially sent a signal to those previously covered states, and maybe others too, that they could now pass new voting laws, potentially restrictive ones, with much less risk of immediate federal intervention or legal challenge.
The guardrails were lowered, basically.
You could say that. And what followed was, well, a significant uptick in new state voting laws. Since Shelby County in 2013, research shows at least 29 states have put 94 new restrictive voting laws on the books.
94 laws in 29 states. Wow.
And many of these changes happened in those very places that used to need federal preclearance.
What kinds of restrictions are we talking about?
A few key types stand out. Strict voter ID laws are a big one. At least 25 new laws making ID requirements stricter have passed since 2013, with another push happening since 2021. Now, supporters frame these as essential for security, preventing impersonation fraud.
Right.
But opponents, and a lot of research, point out they disproportionately affect certain groups: voters of color, low-income individuals, people with disabilities who are less likely to have the specific kinds of photo ID required and face hurdles getting them.
Okay, so stricter ID laws. What else?
We've also seen a lot of action around mail voting restrictions, especially after the 2020 election.
Despite the data we just talked about.
Ironically, yes. Since 2020, 21 states have passed 33 laws, making it harder to vote by mail. Think things like limiting drop box availability, adding new ID requirements for mail ballot applications, shortening the window to request or return ballots.
Can you give an example?
Sure. Texas passed a law in 2021 requiring voters to provide specific ID numbers, like a driver's license or partial Social Security number, on their mail ballot application and the return envelope. And crucially, the number had to match what was in their voter file.
Okay, what happened?
Thousands of applications and ballots were rejected in the first elections under that law simply because of mismatched or missing ID numbers. And data showed those rejections disproportionately hit Latino, Asian, and Black voters.
So, real consequences for voters.
Definitely. And groups like the Brennan Center for Justice report seeing ample evidence that these kinds of laws, post-Shelby, do disproportionately impact communities of color. They also note that turnout gaps between white voters and voters of color have actually widened in some of those areas that used to be covered by pre-clearance.
So it's like a two-pronged thing happening. You have the executive branch pushing for more federal control and stricter rules from the top. And simultaneously, you have states now with more leeway after Shelby County enacting their own wave of laws, often restrictive ones.
That's a good summary. It paints a picture of a really dynamic, sometimes contentious, shifting landscape for voting in America. A real tug of war over control and even over what election integrity fundamentally means.
Okay, so we've covered a lot of ground today. We've looked at this complex dance between the states, Congress, and the president over who controls elections. We've explored the different starting points in the election integrity debate that focus on fraud versus the focus on access and suppression.
Right.
And maybe most importantly, we dug into the actual data on mail-in voting, which seems to directly challenge some of the loudest claims about widespread fraud.
Yeah, it's clear that this push for election integrity, however it's defined, is driving real changes, more executive actions, more state laws, often leading to significant legal fights and real concerns about access for eligible voters. Understanding the constitutional lines and really looking at the evidence seems more critical than ever as these debates keep shaping our whole democratic process.
Absolutely. So as these battles over how elections are run continue with new orders, new laws popping up all the time, here's something to think about. How much centralized control, if any, should the federal government have over elections that are traditionally run by the states? And maybe the tougher question, at what point does that pursuit of perceived security cross a line and start to actively limit the fundamental right to vote for citizens who are eligible?
A crucial question to keep asking.